Good morning. Good morning, everybody. Welcome to Advocacy in Action. As we are opening up the doors here, if you could drop in the chat while we wait to get started, just share, tell us who you are and what brings you here. That would be great.
Thank you. No, that's okay. Okay, thank you.
Good morning, everybody. If you're just joining us, if you could just drop in the chat, tell us who you are and what brings you here this morning. And we will just get started here in a minute. We'll let everybody get settled in.
Morning.
Thanks for being here, everybody. If you're just joining us, if you can drop in the chat just who you are, tell us who you are and what brings you here this morning. Thanks for being here. And we will get started. I'm going to give it one more minute. Yes, happy Thursday. Feels like a Wednesday. Or maybe feels like, I don't know what it feels like, but those Monday holidays throw me off. All right. Great. I'm going to stop sharing. Okay, welcome to Advocacy in Action, everybody. And I'm Sadie Everett, and I am the director of the Regional Autism Advisory Council, or RAC. And RAC is now part of the IDD Education Center at the University of Cincinnati for about 2 years now, which is awesome. RAC hosts several events throughout the month, bringing stakeholders in the community together to address challenges, to support each other, to network, to share resources, all of those great things. So if you aren't connected with RAC, please, share your email. I am going to be sharing a form at the end, a little survey. So if you would like to be connected with RAC and the IDD Ed Center at UC, you'll have an opportunity to fill out that form and I'll get your information. But today is Advocacy in Action, and we've been with my little partner in crime, my little partner in crime over here, Amanda Timkember, and I have been hosting this event. I guess this is about a year now. We're
A
kicking off.
year.
Yes, yeah. Happy anniversary, Advocacy in Action. So we're kicking off the 2026 series with Children's Law, the Children's Law Center, which is exciting. I'm really excited to learn about this service and resource. But really, I just wanted to share what the purpose is of this event, and it is to connect people with resources when you are advocating, when you are supporting students, people with disabilities. So that is really the focus. It is open to everybody. We record these events, so if you can't attend, it will be available to you on our YouTube channel at the IDD Ed, for the IDD Ed Center, and also on our website, my website, which I'll be sharing with you as well. And we also have a Padlet that houses all the things, all the resources. So we really just want to make this information accessible to everybody. And we rotate the times of this event as well. So if you can't come at 9 a.m., maybe next month you can come at 11:30 and so on. So we just really want to try to reach everybody. So, Amanda, do you have anything else to share? You want to introduce yourself?
Hi, everybody. I'm Amanda Tipkemper. I'm Director of Education at Kids Thrive, an independent consultant and a lifetime disability advocate. And I'm just very, very happy to be here and happy to have this event out there as a resource. And please feel free to share the resources of Padlet, share those resources, share the YouTube channel. We record these so that families who can't access or professionals who can't access at the time can at their convenience.
Great. I think we said our spiel, so we are going to turn it over to Nick and Sarah to get started.
All right. Thanks, everybody. Give me one moment. I'm going to share my screen here, and hopefully this goes as smoothly as it did in the run through. Looks like we are set. Okay. Can everybody got it? Okay, great. I got the
Looks
thumbs
great.
up. Um, yeah, my name is Nick Caprino. I'm the Deputy Director at Children's Law Center. Sarah, you want to introduce yourself real quick?
Yes, I'm Sarah Bitter, and I'm an attorney with the Children's Law Center, and I mainly practice in education law.
So real quick today, we're going to get into all this in detail. We're going to try our best not to read slides. We want to keep this as engaging as possible for everybody else, but we're going to go over an introduction of who we are at CLC, what we do, each other, both Sarah and I, what we do individually, and then what we do as an agency. And then we're going to talk about students' rights in schools, particularly students with disabilities. We're going to talk about it broadly, and then we'll get kind of more specific and drill down into certain specific issues as we keep going. Um, we want to keep this, as conversational and as unlectury as possible, although sometimes this can kind of get a little bit lectury. So at any point in time, if you guys have questions, feel free to just you can put something in the chat. Or just speak up too. That's fine too. We can handle interruptions and welcome them, because if we can answer the questions that are most important to you guys in the moment, that I think is what we want to accomplish more than anything. We will say if any questions do get a little bit too fact specific, in the sense that they may not apply broadly to everyone, or they might kind of be an area where we have to start talking about information that probably should be confidential. We would love to answer those questions, and we definitely offer ourselves to answer those questions. But what we would probably ask you to do is to reach out to us afterwards, and we could have a one-on-one conversation and talk about that particular issue. So we'll kind of judge those on case by case basis. But that said, we welcome all questions about anything that you guys have. So real quick, before I go into CLC generally. Sarah, do you want to tell everybody kind of what you do at CLC?
Sure. I am an education attorney mainly. I do a lot of work with children who are involved in the juvenile justice system in Hamilton County. I represent kids in both Ohio and Kentucky. I do some student school discipline matters. I also work on helping children get evaluated for IEPs, helping them with getting their ETRs set up, making sure that we identify what their needs are, and sometimes just working with families to try to help them improve the IEP that they already have. I am I have just started practicing in the state of Kentucky, and Children's Law Center does a lot of work throughout the state of Kentucky and the state of Ohio. I want to let everyone know here that one of the reasons that I really wanted to do this presentation today is I have two children living with autism on the autism spectrum disorder, and I've done a lot of work. I recognize a lot of faces here. I've done a lot of work with families just through the LEND program that I participated in at Cincinnati Children's and UC. And I know that there's just a big need for resources and information. So I really appreciate you having us here today. We're going to take you through these different slides, but what I was hoping for all of you is that you could get to know Children's Law Center. I think I've had a lot of people reach out to me to ask me about the organization, the nonprofit that I'm working with. And today we would like to obviously present to you about education law, but we want to teach you a little bit about the work that we do. We represent children and youth. So I'll let Nick take on the introduction of our Children's Law Center, and then I will take it from there.
Great. Thanks, Sarah. Um, I am also an attorney at the Children's Law Center. I'm a deputy director, so I got my fingers in a lot of different areas. I mainly see my role as supporting all the staff here at Children's Law Center, but then I also represent children in education cases that we'll talk about today. I represent children in high conflict custody cases. We're actually directly representing the children. I represent children in who are victims of crime as well. At CLC, we're a unique nonprofit law firm, is the simplest way to explain it. We offer civil legal services to kids. And then we also engage in policy advocacy and community education, just like this. So, in all the areas that both Sarah and I have talked about, we represent kids directly. It's important to note that whenever we are doing legal work, we are representing the children directly, and we also don't charge for our services. We want to make sure we're providing high quality legal services for free to the children that are in most need. In addition to the work that I've already talked about, we also advocate to help young people who are facing homelessness or obstacles to safe and healthy housing. We help them overcome some of those legal obstacles, whether it is obtaining expungements, fighting evictions, several different legal areas that we operate in there. We advocate for equality and fairness in the juvenile justice system in both Ohio and Kentucky. And we are educating attorneys, family members, community members, health professionals on a variety of different issues surrounding the law and kids that we think provides knowledge that can just help give kids a little bit more understanding and realization of their rights and put them in a better position to succeed in the future. So that is the Children's Law Center, and just a little bit more kind of expounding on what we believe and how we operate and the basics of our mission. All right, now we're going to get into the actual topic. So we're going to start talking about key special education laws, and then as we go, we'll kind of develop into specific issues. But take it away, Sarah.
All right, thank you. You can go ahead and change the slide. Before key federal laws were enacted, it's pretty common knowledge, I'm sure, amongst this group that children and adults with disabilities were really excluded from school. Kids were often institutionalized and were not educated at all. There were 3 landmark laws that changed this, and Children's Law Center wanted to let you know that these laws still exist. They have not gone away, and we would like to just remind you of those laws because these are the laws that pave the way for children to be included in school, to have equal access to their education, and these laws have really improved the lives and outcomes for many millions of students in America. Section 504 was enacted in 1973. The main point of this law was to prohibit disability discrimination. This was modeled after Civil Rights Act, which prohibited racial discrimination, and Title IX, which prohibited sex discrimination. And this was a law, first of its kind for people with disabilities to help them have access to services that were comparable to people who for people with disabilities in programs that receive federal funding. And as all of you know, schools are receiving federal funding. Of course, schools also receive local and state funding, but this was the key that helped bring this law or bring access to education for children with disabilities. IDEA, Individuals with Disabilities Act, is a very significant civil rights law that guarantees a free and appropriate public education for students with disabilities through what is known as an Individualized Education Program, or IEP. Every school in the United States must provide special education and related services to eligible students between the ages of 3 and 21. The goal of this law and an IEP in and of itself is to prepare students with disabilities, children with disabilities, for their education, so they may access their education and learn at school, so they may be employed in the future, and so that they may live independently. There are over 7.5 million. I actually just read this last night. It should be 9.5 million children ages 3 to 21 who have disabilities and who are served under IDEA in the United States. That makes up almost 15% of all students. And as you likely know, most of the students who are on IEPs will attend public schools. And last but not least, the third law that is very significant for people with disabilities in schools and in their education is the Americans with Disabilities Act, also referred to as the ADA. This is a very broad civil rights law, and it prohibits discrimination in public services and accommodations. And it requires that schools provide reasonable accommodations to ensure equal access to educational opportunities. So that could be things like sports or clubs, after school activities. And this is where this would lay in. So as we've said before, all the programs need to be accessible for students with disabilities as well. Sometimes when we think of accessibility, we may think of perhaps a ramp to enter into a building or an elevator, but accessibility for people with autism may be the ability to have an iPad to be able to speak, or to have access to a quieter environment during times when learning. There are other ways of thinking about accommodations. Over 70 million people, 1 in 4 adults in the United States have a disability. 1 in 6 children have a developmental disability. So now we're just going to go into special education. Special education is specially designed instruction and related services. It's at no cost. They're provided to a student at no cost to the parent, and they are supposed to meet the unique needs of the child with the disability. The most important part of special education to remember is just that it's free, and it needs to be appropriate. So appropriate means that it should reasonably be calculated to provide educational benefit to the relationship to the abilities of the child. It should be specific. The needs for the child should be learned, and they should be included into an IEP when that is created. Special education can also mean vocational training for later on in life. It could, as a child is older, let's say in high school or in a transition program from age 18 to 21 or 22, up to 22, excuse me. It can mean specialize in academic instruction, so modifications. It can mean accommodations to being able to enter into a classroom. And it also means, which is very, very important for children, that age 0 to 3, which is early intervention for young babies and toddlers. Help Me Grow in Ohio, and in Kentucky, it's called Kentucky Early Intervention System, formerly First Step. And it means early intervention preschool. All of those areas are covered under IDEA. More examples of what special education would mean. And sometimes when families think about special education, they don't always think Maybe they think about IDEA. Maybe they think about an IEP. Maybe they hear the word FAPE, or they hear the words least restrictive environment, or general education classroom, or special education classroom. They hear different words, but really what special education means in the broadest sense would be having access to be able to learn and including accommodations for that child so that they can learn in that classroom, setting up goals for the child and monitoring progress. Examples for accommodations could be dedicated aid or educational assistants. Sometimes they're called paraprofessionals. The use of an iPad to be able to communicate as an augmentative communication device. It could be special seating in the classroom, taking breaks, and just thinking about the child's day and how to help them access their education. IEPs are a written document. They create goals. Again, it's about tracking a child's progress, really identifying that need for that child, and creating an individualized program that helps that child access a general education curriculum. That is what an IEP is. It is a legal document. There are legal protections under that document. A 504 plan may be created for a child who is not qualified or is not eligible for an IEP. A 504 plan would help the student or the school or the parent create a plan for accommodations for that child. So just so you know, 504 plan is not necessarily a legal document. Some schools actually do create a written plan. Some schools do not. And it doesn't necessarily require a meeting. Some schools do require meetings, but it doesn't require a full special education evaluation for a 504 plan, and it is not necessarily a legal document, but the protections and accommodations under a 504 are legal and will protect the child. All right, Nick, I'm going to let Nick take it to the next level.
Absolutely. So now we're going to talk about, does my child need special education? And I imagine this is a question that a lot of you are already familiar with and you're familiar with the answer. However, I do think it's useful to provide context about the legal basis of why a child may or may not need special education. I know this process can lead even the most educated families to doubt themselves because it kind of just feels like the entire system can be against you sometimes, and you might doubt, you might question like something that you felt you knew forever. So I want to talk about the legal foundation or the basis for answering the question, does my child need special education? And kind of just to piggyback off of what Sarah finished with was 504s versus IEPs. I'm talking about both when I'm talking about special education generally. Everybody's situation is different, but if somebody is at this stage, trying to decide whether their child needs special education, whether they should ask for special education, my default is almost always ask for the IEP. Even if you're kind of on the fence whether an IEP or 504 is appropriate, and then you can get that information, which is always going to be way more robust from the IEP evaluation if you get to that point, and then make a decision with much more robust and helpful information. Does my child need special education? So there's the legal way to look at this question is that it's two parts. One, does my child have a qualifying disability? And we will talk about what those qualifying disabilities are. And also that disability adversely affects educational performance. Okay. Those are the only two things to determine whether a child needs special education. So if anybody, and I mean anybody, doesn't have to be a parent, doesn't have to be a special education teacher, if anybody notifies the school that there is a suspicion that a child may have a qualifying disability and that disability adversely affects their education, that should initiate the process to start to figure out what evaluations we need to get for special education. So when I say anyone, that certainly means parents, and a referral from parents comes with a lot of weight, but it also means the school. And actually, the school is under an obligation to identify those particular children, even if the parent isn't reaching out. For anybody familiar with this process, typically it's almost always the parent that is reaching out, but that responsibility falls on everybody. And it's good that it falls on everybody because not all parents have the resources or knowledge that they necessarily need to be able to know that they even can ask for this. Um, I want to note too, I said the first part is that a child must have a qualifying disability. I want to distinguish the term disability from diagnoses, okay? And that goes in both directions. So, number one, your child may or may not have a diagnosis. That does not mean automatically that they don't have a disability. You can certainly go forward this process even if you don't have a formal diagnosis. The school will not diagnose the child in their evaluations, but they will determine if there is a disability, which legally it is a slight difference. Vice versa, if there just because there is a diagnosis doesn't necessarily mean that you automatically get special education. The question is whether it rises to the level of a qualifying disability that adversely affects educational performance. All that said, if there is a diagnosis, that is extremely useful information that can be used in the evaluation process. So it's great to always share that with the school if you're going through the process. Um, I also want to point out that when we're looking at that question that a child has a qualifying disability that adversely affects their educational performance, we're not just talking about academic performance. We're also talking about behavior and attentiveness. And I think this is something that gets looked over most often. Usually people are thinking about academics, and it becomes a problem when somebody's grades are good, right? The grades are good and nobody really catches on that, hey, there is still an adverse effect because these accommodations aren't being met for this particular child. I see there's a question from Meg Fraser. If you want to either pop in or put in the chat, whatever works for you.
Yeah, hi. Thank you
Mhm.
for having me. I work at Children's Hospital in the Mental Behavioral Health Institute, and we run into a tremendous amount of parents that their biggest challenge is the school. They're getting suspended. They request IEPs. They're not qualifying, and they're just not educated. The families aren't in the system. But the particular case that I'm dealing with now, they have significant behavioral challenges. So there's not like an intellectual disability at this point, but she's got some mental health issues that then affect the behaviors. Um, so I'm glad you spoke on that to kind of distinguish. It may not just be academic, but because she's smart, but it's behavior, and they're not really addressing the behavior. They just want to keep suspending. So,
Great point. And I will get into more specific as we kind of drill down behavior issues and how we need to, number one, make sure if there's any behavior issues, that we need to make sure we get the appropriate evaluations and also make sure the IEP is appropriate. Anybody familiar with IEPs always, sees the most common goals. Getting this number of math problems right this percentage of the time over 3 out of 4 times. But you can make goals like that for behavior, and indeed you should. So, having the appropriate social response in this particular scenario, this number of times, and special educators should and do know how to implement those tests and make sure someone is progressing on a variety of different behavioral issues. So, really great point. I can't emphasize that enough, and we'll definitely talk about that more later in the presentation.
okay, thank you.
Mhm. Um, yeah, so I think that kind of covers the general idea. What is does my child need special education? If you've got a suspicion, um, just ask for it, and we'll talk about what happens. Well, now we'll talk about what happens when you ask for it. So you're asking for a special education evaluation. And in the next slide, I'm going to talk about actually how to ask for it. So maybe this is a little bit out of order, but when you do ask for it, and assuming the school says, okay, we're going to have an IEP meeting to have that, this is kind of the process that we go through. The referral is the person asking for it. Most often that comes from the parents, but it can come from anybody. And then you meet to determine what tests, what evaluations need to be performed, have those evaluations, and then get the report on the evaluations back, determine eligibility. Then you develop the IEP. In that process, you figure out where the child is going to be placed, general education, resource education, or a combination of both. And then you review that IEP and reevaluate periodically. Okay.
May I jump in for
Yeah,
one
please
moment?
do.
Okay.
Mhm.
For the referral, what Nick is discussing is child find. So he's saying that every child must be identified and found if they have a disability. So therefore, a teacher, a therapist, anyone can and should be trying to make the school aware if the child has some type of suspected disability. But I want to just re-emphasize that the parent or the guardian must consent to an evaluation, and that is a really important distinction. They're two different things. We want professionals to understand if you're the pediatrician or you're the developmental pediatrician or you're the psychologist. Yes, you may notice absolutely this child should get evaluated. That would be a great opportunity for you to discuss with the parent that they should potentially make a request for an evaluation at their school for an IEP. But at the end of the day, the school is going to require that there be consent by the parent, and they must sign that document after going through a plan that they are okay with their child being evaluated by the school. Just want to clarify that.
Absolutely. Thank you. Yeah, and it's my personal opinion, and but it's also supported by law. If there is a child, kind of like what Meg pointed out, if there is a child that is having repeated behavioral issues, that to me is enough to trigger the school to say, I think we have an issue here. We need to see if we can get consent to evaluate this child and provide at the very least a functional behavior assessment, which we'll talk about in more
And
depth.
absolutely, that can be an absolute indicator that there's a suspected disability and that an evaluation should take place.
All right, so how to request the evaluation. This is a question we get a lot, and to be honest, a lot of times we get parents who call and say, "I've requested, but I'm not really I'm not really getting a response that seems to be moving the ball forward." So what I want to talk about here is how do I request an evaluation in a way that moves the ball forward? And kind of I'm going to go off on a little detour here for a second. Um, it is great to have legal resources when you have an IEP meeting. Another detour off the detour. I may slip up and say ARC meeting for those of you that aren't from Kentucky. In Kentucky, they're called ARC meetings, Admissions Release Committee. This means the exact same thing as an IEP meeting. So I'll try to keep it standard at IEP meeting, but if I slip up, that's what I mean. Um, so getting back to that, it is great to have, a legal advocate, a special education advocate, or a lawyer in those meetings. But in the state of the world that we are right now, it's not always possible to have for every family to have that. So what I want this to be, or to give the tools that are needed for the parents to be able to advocate for themselves and their children. And a lot of this should be able to give you that legal authority to get where you need to go. That said, Children's Law Center is always here to answer questions and potentially provide advocacy in special education cases. Um, so we've already talked about who can request an evaluation. Anybody. Most often it's the parent. So there's some key things to talk about. You want to use the word special education evaluation. Say the word evaluation. I want my child to have an evaluation. And also, too, it doesn't help that standard that it doesn't hurt to use that standard that I talked about earlier, which is really simply you don't have to use the specific legal phrase or anything, but I suspect or I know that my child has a disability that's adversely affecting their education. That's pretty simple. And if you really if you really wanted to keep it bare bones, you could probably just say that, and that would probably get you over there. That would probably get you over the hump. That wouldn't be my advice, though. My advice would be adding more specific information to this particular request. What are the obstacles your child is facing practically? If you have specific examples, that's always helpful. Again, diagnoses are not dispositive. Diagnoses doesn't mean you do or don't get a special education evaluation, but they're always informative. So if there are diagnoses, include those. Um, if you have suggestions for accommodations, sometimes that's helpful. Sometimes that may be putting the cart before the horse a little bit, but I find it to be particularly helpful because it shows you're going to collaborate in the process. Um, and then any supporting medical documentation that you feel comfortable sharing can also be used and also be to show the school, hey, this is clear. I'm not just saying things. A medical professional has determined that there's these particular disabilities. So my typical advice is to do this in an email. You can do it in email or an actual letter that you deliver to the school, but it always should be in writing. We always want to make sure this is in writing. There's a couple reasons for that. One is, as lawyers, we're always talking about making a record, creating the record. Essentially, what that means is we want to be able to have something to point to say that, hey, we asked for this and here was the response, or there was no response, or something about that. So it's kind of keeping the record, but also it makes sure, it holds the school accountable. They know that there's a request in writing, and they're going to have to respond. Um, Sometimes we see the situation happen where there has been a request in writing, and then there is a response over the phone, a response from the school over the phone. Um, some people like to talk on the phone. And it can be. I personally like to work out difficult issues on the phone much better than an email. That said, when we're asking for a legal right to be enforced, so we want to make sure it is memorialized in writing one way or another. So typically, the way I tell parents to deal with that is have the phone call, talk through the issues, then follow up with an email summarizing that phone call and saying, please, hopefully this accurately reflects what we talked about. Here's my position. Here's what you said your position is. Please respond to me in writing to make sure that, we're all on the same page. So then that takes that phone call, that personal interaction, and then makes the record so you have that. Um, as far as to who to put on the email, it's going to depend on your particular school and how it's set up, the district is set up. I think always the principal of the school is always important. I also think if your district has a special education director, which many of yours should, um, CC that special education director. That's usually enough. I typically advise my parents to also CC if you have someone that you particularly trust in the school that your child works with closely that you kind of you're able to talk with and trust their opinions and decisions. I think it's good to always CC them too, so they're kind of in the loop, and that makes sure that the miscommunication is kept down to a minimum. Um, that everybody's on the same page, and then after you make this request, there will hopefully be an ARC team set up, and from that point forward I would make sure that whenever you're talking about the IEP, everyone on the ARC team is CC'd on those messages so we can make sure there aren't any concerns about miscommunication. Everybody's on the same page. Um, and finally, too, which I don't have any doubt that everyone on this call does, just be respectful in your request. These I completely recognize these issues. They're involving our kids, and they're involving our kids maybe not being treated fairly, or what we perceive as not being treated fairly. So that can evoke a lot of emotions, and I completely respect that, and that's completely valid. That said, we can have these collaborations and we can work with the school in a respectful manner, and we can disagree respectfully. That's kind of the process, right? The school may have a position, you may have a different position. I think it's important to stand your ground, number one, but to just be very clear and respectful. Here's my position and here's why. And also ask the school district, please tell me your position and explain in writing why. you have that position. That I think is key, and I think that's a good way to collaborate. Collaborate doesn't mean one person gets bullied into agreeing with everybody else. It means everybody working and giving their different opinions. I skipped over the 60-day timeline. Once you get into this evaluation, so you request the evaluation meeting, you go into that first IEP meeting to determine whether there should be an evaluation. Once the IEP team determines whether there should be an evaluation, then there's 60 school days that the school has to complete that evaluation. So at that meeting, the school is first going to review all the current information and data about the child, and talk about any pre-referral interventions. I'm going to take another slight detour and talk about interventions. Interventions are great. Um, I have also seen interventions be used as a way to kind of deter an IEP evaluation. Um, and by that, I mean a parent has requested an evaluation and the school has said, let's hold off, let's not do that. Let's try to implement these particular interventions. That's a case by case basis. So I would say if you as a parent feel uncomfortable with that and want to move forward with an IEP evaluation instead, do that. You have the right to do that, right? The school, once that request has been made, there's nothing that says, well, the school has to go through an intervention process. Often the school will, and often that information can inform whether there is a disability that meets that standard. On the other hand, you may be comfortable with going forward with these interventions. You've heard from the school what the interventions are, and you feel comfortable with that. That's perfectly fine too. But don't let the school saying that we would like to do interventions first kind of feel like you're forced to say, okay, I guess we're going to hold off on the evaluation. If you believe an evaluation should be made, stand your ground and say, no, I would like to request, I'd like to go forward with this evaluation. It's a long time while it's pending. So by all means, if we would like to talk about interventions while this is pending, let's do that. If it is determined that the child has a disability that adversely affects their education, then in this meeting, you determine what evaluation should be conducted. So I think I'm getting a little bit ahead of myself here. And yes, so first let me talk about the actual disabilities, and then we're going to get into the evaluations that may or may not evaluate those disabilities. So this is the list of disabilities that are identified, and again, not diagnoses, although some of these can be a disability and diagnoses, so it's like an overlapping set of terms, but these are the quote unquote disabilities that are identified by IDEA that can be considered for special education. Many diagnoses related to academics or behavior can be captured under this. Other health impairment can be one that often captures ADHD, but that can also be captured by other issues as well.
And I'd like to
I,
just add one thing
Go ahead.
here.
Mhm.
A child could be acting out and have a behavior due to their disability. So a child who has a specific learning disability like dyslexia may have behaviors. This could be a sign that there is an underlying disability. So there can be behaviors, yes, that can in and of themselves be the disability, but just know that just because that's another reason to potentially do the evaluation because there could be an underlying disability that's causing the child to communicate through their behavior.
Absolutely. And to that point, if you suspect there's multiple disabilities, advocate to be evaluated, to be noted as all of those disabilities. It doesn't have to be just one. I will say I have been in meetings where, um, because the way the form is set up, the form only allowed the school district to select one. Um, and I made it a point to advocate for. I don't really care what the form says. I'm more concerned with what the law says. And the law says that a child should be evaluated under every disability that they have. So if you believe it's multiple, that's perfectly fine, and you should evaluate for every disability that you believe the child may be that you suspect that the child could be identified under. Again, we're not talking about definitives yet because we're still in the evaluation stage. So if there's a suspicion, state the reason for that.
And I want to add one more thing here. When you're sitting at this planning meeting, the IEP team, which will consist of a special education teacher, maybe a school psychologist, a speech therapist, occupational therapist, the parent, a general education teacher, people will be sitting at that table and will discuss and give the definition of what is intellectual disability, what is hearing impairment. They'll go through, you'll look at the definitions of the ones you think that the child may have. And then the team will decide, okay, we want to do this evaluation, this ETR, evaluation team report and that's what Nick is talking about. He's saying some schools may say, oh, we can only do one. We can only do evaluating on one possible like autism. That's the only one it could possibly be. But technically that's not true. And you could do an evaluation for, let's say, OHI, other health impairment, autism, and specific learning disability. So there, you can do different types of evaluations.
Yeah, great
At
point.
the end, you're likely only choosing one, right? You're only going to become eligible for one, and the team will determine which one has the strongest or the highest number of incidents. But when you do the evaluation, to make it as broad as possible, if you truly don't know, you may get a broader evaluation if you have more than one.
We've got a hand up, guys.
Yeah,
Cassie,
go.
if you have a
Cassie.
minute.
Hi, how are you?
Good, thanks.
Good. So, just to piggyback off of what you guys are currently kind of talking about, if someone went through an ETR process and had a diagnosis of autism, but after the ETR, there was information that was brought up in the ETR, I guess, that would suspect a learning disability, but you've already gone through that ETR process, then is your only option to request like an IEE if the school district is saying we don't require any further evaluation at this point?
I don't, go ahead, sir. Yeah.
I don't believe you would need to do another specific evaluation for learning disability, but what you would do is an evaluation for the child to see if the child has a learning disability. You could cover any intervention or any IEP goal for learning disability and still have an autism diagnosis and category. It doesn't prohibit you from, you could have hearing impairment and autism. You
Right.
could have visual impairment. It's just telling you the category under IDEA that child qualifies, they have to report that to the state. That is their primary diagnosis, but
Right.
you would still want to evaluate for the learning disability and then and then appropriately identify the needs and then address those needs through IEP goals and progress monitoring and working indirectly with it. So you don't have to, the categories are very important, but the evaluations can be very, very broad and
Right.
cover everything that's needed, even under a category like autism. Does that
Right.
answer your question?
Kind of like, but if you're in the process where the evaluation is already completed,
Okay.
and then at the ETR meeting, they're saying, oh, I don't know, this specific, I mean, I guess I'll just be very specific, like a reading learning disability, but we didn't know prior to. And so then I said, so can we do further testing? And they essentially said, no, because we don't care why, we just care that they're making progress. And I was like, well, I care the why because it determines how you intervene.
Okay.
And
Well, in that case, then Nick, you can go ahead and answer that.
Yeah.
But yeah, that's yes, I understand what you're saying there. Go ahead.
And I think what it would come down to is how you feel about the particular interventions, because that's the ultimate goal. So when I first say you want to do as many get test under as many disabilities as you can, you want to cast a wide net. Ultimately, the only thing that really matters in the end is what evaluations we're doing and how we're intervening with those. So I think the first question I would have the school answer is, okay, what interventions are we going to be doing? And are those interventions, do you believe they're going to adequately address the concerns that you have? If they are not, then Sarah, correct me if I'm wrong, but hypothetically, in this general situation, if you don't believe those specific interventions are going to address the concerns, then what I would do is I would request again for the school, like, it's kind of it's an additional request, even though your child has an IEP, you're requesting them to be evaluated again under a different disability. The school would probably say no because they've already gone through that process. And then if you still felt strongly and wanted to, then you could go through the IEE process. But I would first wait to see what those interventions are going to be. And I think the bigger question, probably rather than what disability they qualify under. The bigger question is what evaluations did they do? If there's an evaluation that they didn't do that you don't think captured everything that's going to give them appropriate interventions, that may be a concern. But I'd wait to see what those interventions are, because any adverse effect that your child is experiencing, once they're kind of in this system, needs to be addressed by the school. So even though they may not have had the particular evaluation or may not be identified under the particular disability that you think is the case, the school still needs to address all the adverse effects. And that's the question. If they're not addressing all of those adverse effects, then I think you should probably take action to get them to address that specific issue. Does that make sense?
Yeah. And then if you do your own testing privately, are you able to then go back and get that added to an ETR in between that 3 years, or do you have to wait?
It's not guaranteed. It's information that a school will say, we're happy to provide this, or we're happy to put this in our documentation, but there's no kind of legal requirement that the school says, oh, they've been evaluated outside of the IEE process, let's say. They've been evaluated independently. Oh, we have to accept this. It's kind of just additional information. The school would, kind of requires the school to take that information. They can't just ignore it, right? If it's in the record and they have the information and they're just ignoring it, that's not something that's going to look great on them. But it's also not something that's going to require them to move forward on that independent evaluation. Does that answer that question?
Yeah, I think so.
Okay.
And I think obviously, making the argument, bringing in the information and talking about the specific needs of the child. And if you can identify, again, that this is a very specific area that the child needs an intervention on, and you can work with the IEP team to change the IEP goals, to individualize it, to address that particular issue. I think that would be a great avenue to take if you're able to work with your teams to do that. Um, I think the more knowledge that the IEP team has to help intervene and give that child what they need will help them to provide that educational benefit, right? You're always going to try to make that argument that there has to be a relationship to the abilities of the student, the ability for that student to learn, and that the child should receive educational benefit. If the child can't receive educational benefit because their needs aren't being addressed, then that would be a violation of FAPE, and that would be an argument that you could make, as a parent, and if you're an advocate, could make as well. So you definitely don't want to leave anything, if you don't want to leave anything out of an IEP. So if you find out later, oh, this is the reason why. Imagine if you had learned that actually your child had hearing impairment, and that was a reason why. You wouldn't leave that out, right? And it doesn't mean you have to go back necessarily and do a whole evaluation on hearing impairment and then have that category to address the hearing impairment and to add those goals and add those interventions and accommodations in the IEP. So that's how I would address it. But legally speaking, yes, you could do you could request an independent evaluation. You could try to get the school to pay for that. There are legal avenues you could take. Hopefully you would be able to work with your team because the school would be willing to work with you to address that.
Alicia, I hope it's okay that I share your chat, but I think it kind of sums up what we said in a much more eloquent and succinct way. She said that in the chat, she said typically our district would add that information, that independent, that private evaluation information to the profile of the IEP, along with interventions that are happening. So this is informative and will be captured on the next ETR. Again, I think that's kind of the essence of that.
Yeah.
Thank you for the discussion. Great questions,
Yeah,
everybody.
yeah. Sometimes I just feel like with an autism diagnosis, because that's like a heavy hitter, right? It covers multiple disciplines. Like they want to use that and just blanket everything into that, like, oh, well, this is caused because they have autism, and not kind of weeding out some other things that could need to be addressed more specifically, I guess. And I don't know if anybody else has encountered that or not.
It's not an uncommon issue that I've seen with my families. So I kind of this is great. I love the conversation, but I want to make sure we cover as much as we can. So I might go fast over some of this stuff. If people have questions about it later, please reach out. These are all the different types of assessments. I really want to talk about the functional behavior assessment because it gets into issues that we talked about earlier and about behavior, but we do that when we're going to talk about behavior more specifically. Um,
And
as
I
far
just want to, I'm sorry, but I have to do this because almost every single child that I work with, I've had this during an evaluation, speech therapy, assessment evaluation. If a child can speak, that's not a bar for receiving an evaluation in speech therapy, right? If you have autism, sometimes I will be confronted with an argument that the child does not need an evaluation during the evaluation process, during the ETR meeting, planning meeting, because the child is able to speak. And that is not why you would do a speech evaluation. Many children are unable to communicate. They do not have functional communication. They're not able to have proper behavioral interactions with their peers at school. So it's always about how that child is functioning in the school and how they're able to access their education and the whole child, the whole learning experience of being in school. So a speech therapist can really understand the social, emotional levels of a child through a speech evaluation. And I would say the same thing for occupational therapy. Just because a child can write their name and has great, excellent penmanship does not mean they don't need an occupational therapist. Occupational therapists help children organize themselves so that they can get ready to learn. It is so much wider encompassing, and an OT can really dive in. And when they do that evaluation, you will learn a lot about the needs of that child. So I advocate often for having at a minimum, if the even if at the end they don't qualify for speech or occupational therapy, having those two types of therapists on board is a very, very helpful service that your school can provide to help your child access their education and learn in school.
Great. Perfect. Yes, thank you for adding those points in the evaluation. As far as the evaluation goes, one kind of at the end of the evaluation, there'll be a big report. One little tip that I always kind of tell parents, you can ask for the evaluation before that IEP meeting, that ETR, the IEP meeting that is the ETR meeting, the evaluation team report meeting. It may not be fully complete before the meeting. Off schools are putting in a lot of resources to these. I definitely recognize that. And sometimes they're getting done at the last minute, which is not a judgment at all because I can sometimes be the king of getting something in last minute as long as it's in before the deadline. That said, please ask your school, hey, can you give me the ETR before the IEP meeting? And if it's not all complete, that's fine. Give me what is complete. There's going to be parts of it that are complete. So ask for that so that you can review it before the meeting. You'll go into the meeting, you'll review that ETR, and everybody, the team will determine whether the child is eligible for an IEP at that meeting. If they are eligible, that's going to explain this process. I believe I will touch on if they're determined not eligible and you still want to pursue an IEP, there is a step you can take that is called an individual expert evaluation, IEE, that we'll talk about briefly later in the presentation. All right, Sarah, now to you.
All right, so now we're going to move into the IEP. We've already touched on this, excuse me. This is a document. This is a legal contract. It's a document explaining how the child's disability, what the disability is, what the needs are of that disability for that child, and how it would affect their education. This is a document that describes the education, behavioral goals that the school is going to work on with the child. It will list the accommodations and supports and services that the child will need in order to achieve their goals. The biggest takeaways that I want you to think about when you think about an IEP is it's a place. The IEP is not the child's education. The IEP is a guide to help the child access their education. It is not what the child does the child doesn't go to school every day just to learn their IEP goals. Your child goes to school to learn math, reading, science, art, history, gym, all the classes, right? Every subject. But the IEP is a guide. It is a legal document that helps lay out the plan, the individualized plan to help your child access that education. Your child in a perfect world and in a great IEP. I'm not saying your IEP is not great if this doesn't happen, but you want to work towards having your child have grade level information being taught, curriculum being taught to the child at the level that the child is. So that's where modifications come in. You can work, a special education teacher and general education teachers do know how to modify information in order to teach a child. So if your child is in sixth grade and they're reading at a second grade reading level, they should be receiving sixth grade math, but at a second grade level. I know that sometimes seems that impossible, but it is not impossible. Teachers do know how to differentiate. They know how to chunk it. They know how to make things appropriately delivered to a child so that they can still make progress, still learn those grade level content. Math is a little bit harder, but definitely you can think of areas of reading or language arts that you could do this as well. The key for an IEP to think about too is just having annual measurable goals. You want to be able to have a goal that meets the need of that child. So if there's a behavior, your child is receiving an IEP because they're under other health impairment, for example, because they have ADHD. The way you knew that the child needed some type of evaluation and then eventually turned into receiving an IEP was because of behavior, because there's challenges with attention or some other type of behavioral challenges. If that occurs, then a goal can be written to help teach that child executive functioning skills, different types of skills so that they can access their education. Therapies can be provided through speech therapy or through occupational therapy. Accommodations can be listed on that IEP. So an IEP again is the document that houses the information about your child's disability, the needs of your child, and the plan moving forward. It's a working document. If at any time you learn that your child has hearing impairment, then you would bring that information to your school and you would bring that in, and then the team would need to start to think about, okay, what does that mean? What type of accommodations does a child need if they have hearing impairment as well? Again, least restrictive environment, that would be ultimately the goal. Not every child will always be in the general education classroom, but that is generally what an IEP is laid out to do, is to help a child with a disability be included in their school. A 504 plan, we've talked about it already, so I'm not going to go over this much, but a 504 plan, every school does them differently. Some schools would like for you to come in and sit down and actually write a document. It's not necessarily a legally binding document like an IEP, but the requirements to provide accommodations to your child for the needs that they have as a child with a disability are legally binding. So what to expect when your child has an IEP, or if a child has an IEP, you want to, or a client or a patient has an IEP. An IEP is not a one and done type of document. It is a working document. It does last technically for 1 year. It needs to be reviewed annually. You would have at the meeting, you would have the parents attend the meeting to provide input. You would have a regular general education teacher provide input about what the general education curriculum is for to be able to provide context to what the general education would be for that grade level. You'd have a special education teacher there that would likely be the one leading the meeting. You may have an assistant principal there or some other administrator there that's able to make district level decisions and sign off on different requests and things like that right there at the meeting. If appropriate, it's typically encouraged for children to be at the IEP meeting. If it's appropriate, it needs to be age appropriate and disability appropriate. Some children do really well at IEP meetings. Sometimes children have extreme anxiety and do not feel comfortable attending. That's something that you have to decide as the parent. How often do they occur? Again, you can request an IEP for something significant, really for any reason. You can request one. You would want to do that, if possible, in writing. Clearly increased challenges at school, if grades are really significantly changing, discipline issues. There's, behavior can often be communication to you that something is not going right, and their services are not supportive enough to help that child learn. There could be a new medical diagnosis, and that would be another reason. But ultimately, you should have an IEP meeting once a year. And you should, by the way, and it's not on this slide, but you would also be evaluated every 3 years. You have to continuously, you have to remain eligible for an IEP in order to receive an IEP. And that's done through the ETR or evaluation team report process every 3 years. Some general tips on how to prepare for an IEP. It always helps to go back and look at your last year's IEP and really look at the levels and look at the progress monitoring that your school has sent to you. You'll get progress monitoring reports on those IEP goals. Look at those and see if you feel like your child's been making adequate progress. Think of any questions you might have about that, about the progress goals, and any ideas you might have about future goals that you feel maybe are not strong enough, or you want them to broaden, or you may have other areas coming up that you would like to address. You want to consider who to bring to your meeting. You may have an advocate come with you. It's very common for parents to want to have another family member join them. It can be very, very helpful to have another person with you because IEP meetings for your child can be challenging and feel very personal. They're advocates. Sometimes people have attorneys join them as well. But I think the most important thing for an IEP meeting is to always remember, if you disagree, please have them note that in the IEP itself or in a prior written notice. Just let them know respectfully, be very, very calm and very collaborative, and just say, I just would like for you to please note this disagreement in this IEP, reflecting this in the IEP meeting notes.
If I can just jump in, and I'm kind of just thinking this in the moment. One other little kind of tip for IEP meetings that I use, sometimes it seems like, everyone, the parent is kind of one side and everyone else is kind of like the unified body of the school. And it's kind of school shouldn't be like this, but it feels like the school against parent. I will say, I don't believe in a lot of cases that's intentional by the school. It's just kind of the nature of the way it's set up. Please kind of reframe your mindset that this is a team. Everybody is individual. And I'll also say that the school is not, almost always the school is not unified in their opinions. Everybody has a different expertise and everyone has a different perspective. And you can often find, while there may be some people on the IE team that aren't aligned with your thought process as much as you would like, there's probably someone else who is a member of the school, often special education teachers, sometimes a school psychologist, and it really can be anybody that is more aligned with you. So do your best to kind of identify those advocates and give them opportunities to speak. Because once someone from the school side, quote unquote, is kind of advocating for you, what you want, that kind of moves the ball a little bit in your direction. So I think that's kind of a little informal tip in IEP meetings. Really treat this as a team effort, and that means you are an important individual, and every single person on that team is distinct and has an important expertise and perspective. So lean on that.
I agree wholeheartedly with what Nick just said. And in fact, this kind of goes a little bit into the next slide, but A very good approach is to, you might have an idea of what you believe would be helpful for your child, an accommodation to include in the IEP or to include in the IEP meeting as a discussion to figure out where it may go on the IEP, if it's an accommodation, if it's part of a goal, um, or part of a service that the school may or may provide. But one very important thing that you can do is you can ask those professionals in the room, ask them directly, ask the occupational therapist, ask the speech therapist in the middle of the meeting, what do you think? Can you provide with what has been working with my child during speech therapy or during class? What's helpful? And then maybe they haven't tried yet a visual schedule, or have we considered, your child keeps jumping up and moving and running away. Could we try movement breaks? Could we try different seating, maybe sitting toward the front of the room or the back of the room? But these are great. Sometimes just if you're not sure, or if sometimes it is a great approach to just simply ask the professionals in the room their opinion. You may have your own opinion, but it will bring out that thought, potentially bring out that thought process for that individual to really think about how to problem solve for that child if there's an issue. One thing I definitely like to point out at for every parent during an IEP meeting is always don't forget the transportation. Don't forget transportation needs and what that child might need. That's a really important thing. If the child needs to get to school earlier or later, can't handle crowds when they arrive to school, or can't handle crowds when they leave, or can't handle crowded cars, things like that, or buses, just remember transportation is a really big area that we sometimes don't talk about in the IEP meeting because we just forget that part. So please don't forget that.
We're back to me. Okay, so school discipline for children with disabilities. I'm going to really quickly talk about how school discipline works when we're just generally when we're talking about students without an IEP or 504, just so we kind of have a foundation. So I'm going to put on my law school professor hat and talk about due process. So the Supreme Court has found that even students have the right to due process when they are at risk of having some type of discipline at school. You guys have probably heard about due process before. Most often it comes up in criminal cases, right? A criminal defendant has the right to due process. Well, students who get in trouble have the right to due process as well. But the question of the level of due process is really what is considered. So due process, if you're charged with a crime, is very high. You have the right to a trial, all of these things that the court, the system has to go through to be able to find someone guilty. If you're getting in trouble at school in a way that the school is saying we're going to either take you out of school for a limited amount of time or change the placement, you have the right to due process. If the school is going to suspend you for 10 days or less, that level of due process is extremely low. Essentially, it is the school says, "Hey, you did this. Here's the offense that you committed. We are going to remove you from school for 9 days. Is there anything you'd like to say?" And then the student can say whatever they want, and that's the end of it. That's the amount of due process that the student gets. If the suspension or is going to be 10 days or more, which would be defined as an expulsion, then that student has a right to a hearing in front of a neutral arbiter. That neutral arbiter is almost always, well, not almost always, I would say it's often school boards, but sometimes it can be a DPP or someone appointed by the superintendent to hear these expulsion cases. And when I say a right to a hearing, that means you have the right to put on evidence, listen to the evidence that the school is giving, and then make an argument why you either didn't commit the offense that's being alleged, or if you did, why you should not be suspended for X amount of time. So that's the base level. That's what we're talking about. Now, when someone has an IEP or 504, they can't just go into that process. The question that needs to be asked if a student is facing a disciplinary hearing, or any type of discipline, is the punishment going to change the placement of the student for 10 days or more? And change placement means exactly what it sounds like. Are we taking them out of their traditional class setting? So that doesn't mean like traditional expulsion, suspension. It also means like if the school is going to put that child in an alternative school, that is a change of placement. Anything that messes with the placement that is defined in the IEP, this much time as general education, this much time in resource education, anything that's going to change that is considered a change of placement. And if that happens for 10 days or more, the school has I'm sorry, the IEP team has to have a manifestation determination review, an MDR, before any type of expulsion process goes through. And this has to happen within 10 days of the suspension. This 10-day rule does not have to be consecutive. We're talking about a school year. If there has been a 2-day suspension and then a 4-day suspension and then a 5-day suspension, now we're over, and those have all been separate. Now we're over 10 days. That triggers the requirement of the MDR. So the special education team, the IEP team, has to have this MDR. A lot of times this can be framed like some type of disciplinary hearing. I want everybody to kind of not think about it that way. This is an IEP team meeting. We're talking about the issue of potential discipline, but it is an IEP team meeting where we're asking special education questions. So what questions are we asking? This slide kind of lays it out pretty succinctly. The first in the law, these questions, and I think schools often do these questions in reverse because that's what the law says, but this is the more accurate way to think about these questions, because really you have to ask question one before you can ask question two, I believe. But the first question is, was the behavior that caused the discipline referral, is that because the school did not follow the IEP? If the answer to that is yes, should be the end of the analysis. Kid goes back in school as if nothing happened, and school needs to fix the IEP. Or fix I'm sorry, not fix the IEP, because the IEP should provide that. The school needs to fix their process so they're following the IEP. It also, if it has not been done, if the answer is that the school did not implement the IEP correctly, they may be required to reevaluate or start a functional behavior assessment. Most often, schools are not going to agree that they did not implement their IEP. I don't think I've ever had an MDR where the school answered, that they did fail to implement their IEP. Sarah, you may have an example of it happening, but I don't. The second question is often the one where the school will often, but not always, admits that the answer is yes. And that is, was the child's behavior, the behavior that led to the discipline issue, caused by the disability, right? A lot of the issues that kids are having being referred to the disciplinary process for are impulse control issues. Speaking out, saying certain things that they shouldn't say, doing something that's impulsive, which can often be related to whatever disability they have been identified as. So if the school answers that question, yes, that the child's behavior was caused by the disability, and really the another way to look at that question is, was this child's behavior a manifestation of their disability? That's why it's called a manifestation determination review. Then the school can not discipline the child any further, cannot expel or suspend that child for 10 days or more. They could do less than 10 days, but they can't do 10 days or more. And the school is required to reevaluate a functional behavior assessment and update or implement a behavioral intervention plan. We're going to talk about those in more detail. Okay, so if the school failed to implement the IEP, I'm sorry, if the school implemented the IEP but the behavior was a result of their disability, of the child's disability, then the school is going to be required to do a functional behavior assessment. Definitely, if the school has not done a functional behavior assessment already, obviously they need to do this. If the school has done a functional behavior assessment, They need to update that functional behavior assessment. And the goal of updating the functional behavior assessment is to create or update the behavior intervention plan. So the functional behavior assessment, the FBA is one of those evaluations that we talked about at the beginning of the process. What I often see is students are evaluated, they don't get a functional behavior assessment, even though behaviors are kind of percolating under the surface. We're kind of seeing those. And then later they get in trouble, and then we have to go back and say, okay, we need to get a functional behavior assessment. Sometimes I kind of hint, should have known that we should have done this earlier, but we're here now. Let's do this. And we'll develop a behavior intervention plan. I'll talk a little bit more specifically about what a behavior intervention plan is and how that helps, but I'll jump to Meg real quick because I see you have a question.
We actually have a couple questions in the
Okay,
chat, Nick, that
great. Yeah. Yeah,
I've been,
we
sorry,
can
Meg,
take
sorry.
a
Um,
quick break and I'll try to answer some questions and we'll get back to BIPs.
okay, so, and this might be something that we have to address afterwards because it's not specific to the BIPs, but I have a daughter with a speech IP. I'm struggling with the district to consider auditory processing deficiency or disorder.
I think that's probably a question that we'd ask. Reach out. Our contact information, our emails will be at the last slide. But yeah, please email Sarah and or me. And yeah, we'd answer that question. To be honest, I'd have to do a little bit of research
A
to
little
figure
more
out the answer to
information.
that question. But yeah, we can hopefully give you some guidance there.
And Danielle asked, how would a CANS assessment fit in with the IEP request? And I did respond to that, Nick and Sarah,
Okay.
just so you know, because a CANS assessment is a specific tool used by Cincinnati Public Schools.
Okay.
It's a behavioral health tool. And Danielle, the same. I would say the same for this situation. Contact Nick and Sarah if you want to dig into that a little bit more. So thank you, Meg. Thanks for
Absolutely.
waiting.
Awesome.
Sorry. Yeah, just real quick. Do you have to have an IEP to get an FBA, or like how do those pieces work?
I mean, I've never seen an FBA without an IEP. You could certainly always ask the school. I have seen BIPs, behavioral intervention plans, as part of 504s. Um,
You don't
I
have to, I don't believe you have to have an IEP to get
yeah,
to request a functional behavior. You do not. You can request a functional behavior analysis, you can assessment, you can request it for behavior. And it could end up, of course, triggering that process of an evaluation for an IEP, but absolutely. Schools should be putting, they're supposed to do response to intervention, or they do some type of MTSS, multi-tiered systems of support. They should be looking at every kid and knowing what their needs are. And if you're having so many behavioral challenges, and you don't have an IEP and you have, again, it could be a child fine violation too, right, by the
yeah,
school. But if you say the words functional behavioral assessment to your school and say, I'm requesting this, it should trigger to the school district that there's an issue and that perhaps you need to actually sit down and have an evaluation for an IEP, and then obviously still do a functional behavioral assessment for that behavior. I feel pretty confident that you don't have to have an IEP for that.
yeah. If you're, and I might have misunderstood the question, but yeah, I think if there actually needs to be an FBA, that to me says like, well, then there needs to be an IEP. Also, not that you need to request once you request the FBA, that's like requesting, and that's just a way of specifically requesting for an IEP because is that correct, Sarah?
I
I
think
think
what I think I'm kind of what I experience this with many of my clients. Um, there are a lot of kids that are not being evaluated for IEPs. That's why we wanted to talk about evaluation so much, especially kids that are having some type of behavior, and they have a disability. Many of the clients that I represent are in the juvenile justice system. Many of them haven't. Many of them have a disability. Many of them have not received an evaluation. Some have, and the goal is it's related to behavior and it's somewhat vague. And so we have to actually redo another evaluation, and we have to rewrite the IEP goals to be more specific and to actually learn what the disability is. Sometimes it's dyslexia, sometimes it's ADHD, but there's a lot of trauma that has made major impacts on kids and creating disabilities themselves, right? So I think if you know that there's a lot of challenging behavior, that is a sign that a request for an evaluation should be made under special education law. And then at the same time, yes, request the functional behavioral assessment no matter what, because you want to address the behavior. You need to know the function of the behavior so that you can create a positive behavioral intervention plan to address it immediately. That will also create documentation, and it will be protective for that child to indicate to the school that this child does have a suspected disability. So if there is some type of disciplinary action, like you get suspended or expelled, you would then therefore get that IEP meeting. Even though you don't have an IEP, you would get the MDR because the child has a suspected disability. If they have a 504, that means you have a disability. If you have a disability or suspected disability, you should receive the protections under IDEA. IEP or no IEP, you get those protections. And as far as the FBA goes, that is a tool that is universally used by schools in order to address behavior. And that's related to positive behavioral intervention supports, which is through state law. It's through multi-tiered systems of support, which is curriculum for schools that's required by the state. So you don't need an IEP to request an FBA, but it should definitely trigger the thought of requesting an evaluation for an IEP.
Yeah.
Okay. Sarah, so much.
Yeah, that's great. So what does the FBA actually do? What's the goal of it? And that's to develop a behavior intervention plan. Sometimes I've seen FBAs developed and then not take that second step. An FBA doesn't really do much, except for maybe help set some goals in the IEP. But really what we want is a behavior intervention plan. And there's all different types of formats. Every school district has a different type of format, but they have for a behavior intervention plan. But the idea is identifying different levels of behavior. Usually they're kind of categorized in kind of mild behaviors to severe behaviors. Identifying what those, first identifying what typically triggers those particular behaviors, what those behaviors look like, and then finally, what are some techniques and strategies that the schools need to follow to de-escalate those behaviors. So a behavior intervention plan isn't about making the child do one thing or another. It's about requiring the school to follow a process to make sure, to do their best to make sure a mild behavior is identified and dealt with in a de-escalating way so it does not become a more serious or severe behavior that may lead to the disciplinary process that we talked about. Behavior intervention plans I've found to be super helpful. Go ahead, Sarah.
I want to add, because I know we don't have that much time, what he just said is correct. They are very, very helpful. The function of the behavior, learning, the team needs to understand why this child is having the behavior. That in and of itself could cause you to do an evaluation for special education. But the key too is to teach new behaviors. The behavioral intervention plan will actually cause the school district to teach that child new skills. And that is the point of an education. That is the point of special ed. So they are extremely helpful. I highly recommend that these are underutilized. FBAs and BIPs are underutilized, and we as advocates and parents and anyone working with kids with disabilities needs to understand the importance of these tools for us under the law.
Yes, absolutely. We've kind of, so this is getting into the section, what if I have disagreements? How do I make my voice be heard? These slides will be provided to everyone, and we've kind of touched on all of these specific issues, so I'm not going to spend too much time because I don't want to go over. In general, I just kind of want to leave everybody with this thought. Just remember, you are a part of the team. You get to speak up just as much as anybody else in the team. And not only that, I always kind of assert you're an expert in your child. You're the only expert in your child, which is the most important expert when you're talking about these issues. So lean on that and advocate as if you're the expert in your child because you are. There's other experts too. in that area, in areas that you do not know. I am not great with school psychology. I'm not a psychologist. I am not trained in neuroscience whatsoever. I will lean on the school psychologist on their expertise on particular issues. But please, feel confident in the expertise in your child. If they're identifying behaviors that you see aren't consistent with home, bring that up and talk about why that difference may be the case. And that can sometimes be a good way to identify solutions. So these are all specific tips that you can go through now and go through with the slides later. But in the end, just really do your best to feel empowered in those meetings, because in fact you are. You are not someone just to be told what's going to happen. You're someone who gets to give input about what should happen.
And our final slides, we would like to invite you to please, for educational resources, we hope that you will please visit our Children's Law Center website. We have a lot of resources on our page. I know that many people here are somewhat new to learning about Children's Law Center, so we hope that you'll go on our resource page. If you look under education law, there's a whole section on special education. We have resources for families who live in Kentucky. We have resources for people who live in Ohio. Some of it's obviously for both states, but we have a IEP ARC meeting guide. We have 504 guide, and we have some tools there that we would like to share with all of you. So please go onto our website. And we wanted to leave some room for questions at the end, but we hope that if for any reason you have anything specific or even broader questions, that that you could reach out to either one of us. Our emails are listed there. We appreciate your time, and we know that many of you on this call are advocating for children and youth with disabilities, and we truly appreciate all the work that you're doing. So thank you for having us.
Yes, thanks for having us, and ditto for all the work that you're doing. It's extremely important. Any other questions or anything else?
Are we allowed to go overtime? I mean, I'm okay to do that, but
Yeah.
are you good with that?
Yeah, I think it's if anyone
Okay,
wants
sure.
to.
If anyone wants to ask you, and in that case, if we are allowed to go over on time, we do want you to know that a behavior intervention plan should get added to the IEP, right? That would be the goal. Because if you just went through a lot with your child and you went through you went through a suspension or potentially a manifestation determination review, that's a pretty serious thing. Clearly, that needs to be addressed. And then once that behavioral intervention plan is created. I like to call them positive behavioral intervention plans. But once that's created to create new behaviors and to teach new skills to that child, then you would want to add that clearly to your IEP. So
Yes.
please know to do that because it's very, very helpful and it will be protective again in the future likely, potentially any other behavior may occur.
On that note, I have had some schools say before, it's a behavioral school in general, a public school but it's a specific school placement that's designed to deal with behaviors. And when I've requested a behavior intervention plan, the response I've gotten was, well, we're a behavioral school. Everything is a behavior intervention plan that we do. And if you ever run up against that, I wouldn't accept that for an answer because number one, it's not supported by the law, but also two, every child is specific and has specific triggers and needs specific techniques or strategies for de-escalation and helping them learn how to cope. So stand strong in your request. No, I want a specific behavior intervention plan because that's what's required. Tracy, you have a question?
Well, I just have a comment. I work for a local county board of developmental disabilities, and I just want to emphasize I work specifically with children in transition teams that such an importance to invite, if you're connected to a DD system, invite your case manager, your service support administrator, whatever it's called in your area, to your IEP and ETR meetings, because that's information that we can then take and help do planning on our end as well, find additional supports and services in the community, if it's with behavior related things or other things like that that we can assist with. I just think it's really important that systematically we're engaged across the board with other agencies and multi-systems that are providing supports. I mean, juvenile, you've mentioned juvenile court. We go to court hearings. We do all those types of things. So just to encourage people that if they do or they are engaged with DD, to please make sure you're reaching out and inviting our teams to support you and assist you in those things.
Thank you
Love
very
that,
much for
Tracy.
that information. I will, Tracy, that's a really, really good point. Many of the clients that I represent have never been involved at all in the county board evaluation or intake process. Many of them, many children do have a developmental disability, most likely, but they have not had any access whatsoever. So how would you suggest I do that for my clients?
Well, in the state of Ohio, like each county, we have a county board system. So they would just need to reach out to their local county board and request eligibility to have an eligibility assessment completed. And then they would go from there with it's different in the eligibility assessments, the same for the state of Ohio, but then the process for each county is probably a little bit different.
And if they're served through Job and Family Services, they could still go ahead and reach out to Hamilton County Developmental Disability Services.
Yeah, anyone, like even like if there's a school district, they can call and make a referral, then we would just be mandated to then reach out to the parent or guardian because again, we would need their request and their consent to move forward with completing any type of assessment for eligibility. So even if sometimes we'll reach out to parents and the parents will be like, "Who are you? Why are you calling me?" I'm like, "Well, the school system called and suggested that we, touch base with you and we'll find some people are very receptive and others like, no, we're good. We don't need you. So, but we take referrals from any source and we'll reach out to that. We would just need, of course, to know, the parent's name and contact information and things like that as to, how to get in touch with that person.
Thank you very much for that information.
Yes, that's fabulous. Any way that we could make this more of a collaborative process, I think is amazing with the whole community. I sometimes this process can be thought of an us versus them. And I really want it to be more of just a collaborative process as a community. How are we figuring out to give these kids all the chances and resources they can? So that is a great tool that I hadn't thought about before. Anybody else have any questions or thoughts?
Thank you so much to the both of you.
Thank you.
Yeah, thank you so much. This has been super informative. We've included all the things in the chat. So check out Children's Law website. Please fill out the survey if you haven't already. We just want to keep improving this event and serving the community on what you need and what resources you need. So definitely check that out. And I have included the RAC website that houses the information on advocacy and action, which the dates right now, I'm updating the dates for 2026, so just ignore that. But the YouTube link is there and also the Zoom link so that you can join the next meeting, which happens on the fourth Thursday of the month.
Thursday, February 26th at 11:30, we're going to have an advocate panel. So if you have questions, more questions, that's a great opportunity to talk to a couple of local advocates. Jenny's on the call. Jenny's one of those advocates that will be joining us for that call. So we hope to see you there.
Thanks, everybody. Have a
Thank
great day.
you.
Thanks,
Have a good
everybody.
day.
Thanks, Sarah and Nick. Thank you so much.
So
Thank
much.
you. Bye-bye.
Thank you, everyone. Have a good one.
Bye, Danielle. Thank you for coming.
No problem. Thank you, Amanda.